It's a great day here at Elville Associates. Welcome to our webinar series. My name is Jeff Stauffer, Community Relations Director with Elville Associates, and I'll be your moderator today. I'm pleased to share with you our topic, which is Understanding Estate and Trust Administration, the Postmortem Process for Estate and Trust Administration Explained, presented by Elville Associates Managing Principal and Lead Attorney Stephen Elville. This is a presentation we've offered on a quarterly basis for many years, and you're in the right place for high-level legal education and discussion today. With that said, we encourage your general questions, so please note them in the questions panel on your screen, and we'll pause periodically to address them. As always, your questions they help the presentation and they add value. They help others learn, so pose your questions at any time. Yesterday by email, you received today's presentation slides in 2 checklists that Steve will be referencing. And also, if you didn't receive them for some reason, they're in the section marked handouts on the panel on your screen to download at this time. We also have several professionals on today's webinar, so thank you for being here as well. 1.5 continuing education hours are available for most everyone in attendance. So if you'd like to submit an ID number or your accreditation for me to provide a certificate, or submit your information to the CFP Board of Standards, please send that to me today if I don't have it already. Everyone will also receive a post-webinar feedback email right after the presentation. Please take just a couple minutes to fill out this very brief survey. Offer us your feedback and thoughts about today's presentation. We always read and value everything you have to share. We do, as I mentioned, have a couple of really great presentations coming up at the end of this month and in March that are a direct result of your survey comments. So thank you for your attention to that. And here at Elville Associates, we always want to be a resource to you and your family for your planning needs. We work with hundreds and hundreds of clients on a yearly basis. We educate thousands of people as well. So any planning needs that you have to address, old documents that may need to be reviewed, or perhaps another matter, Steve and our firm and our team here are always here to help. So I want to offer a brief introduction for Steve and the firm. Before we get started, we have a quick poll to offer you to learn what your experience is in estate and trust administration, and we will jump right in. We have a lot to cover. So just a bit about our firm. We've been around for 14 years here in Columbia. We have several different practice areas that we help our clients with, including estate and trust administration, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, tax planning and asset protection. We have 9 attorneys, 12 staff members, and 5 locations. Steve and I are coming to you from the Columbia Gateway Community location today. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. And we focus on education a lot here at Elville Associates. We do that through our planning processes with our clients. We offer many, many educational webinars and workshops in the communities that we serve each year. And also by way of our accredited client care program. We're one of only a couple firms in Maryland to have a client care program accredited through the Client Care Academy in Boston. We also work with the ideals of client education, collaboration, and compassion in mind every day here with every client at Elville Associates. Just a bit about Steve. His work as an attorney for the past 23 years has been centered in elder law, special needs planning, and estate planning, with an emphasis in the areas of tax planning and asset protection. A member of many different national membership and professional organizations, including the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys, among many, many others. He works to offer peace of mind to clients by creating solutions to their needs through counseling, client education, and the use of leading edge legal technical knowledge. Steve is a very seasoned presenter and speaker. If you haven't heard him present before, offering many webinars, workshops for businesses and their employees, speaking at conferences, and offering continuing education events. Steve was also named to the Maryland Super Lawyers list for a 9th time and 8th consecutive year in 2024. He also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charity that he founded in 2014. I'm very fortunate to be the executive director of. So if you'd like to learn how we work to make a musical difference in the lives of children each day, I would love to share our story with you. So feel free to reach out to me and we can discuss that in a little bit more detail when we have more time. Right now, we're going to jump into our presentation after we learn just a bit about you and what has brought you here today. I'm going to launch a quick poll. And the poll is, what has been your experience with estate and trust administration to date? And the choices are, since I have my glasses today, I can read the choices. I've been the executor of an estate in the past on my own. Second, as an executor, I sought professional guidance throughout. Third, I may be asked to be executor of an estate in the future. Fourth, I want to keep my planning in order to keep costs down. And last but certainly not least, I'm an advisor here to learn to better serve my clients. So take about 20 seconds to make the choice that best suits your situation so we know what's brought you here today. Steve can kind of tailor the presentation. I just went through the estate and trust administration process for my aunt a while back that was finally settled in November, and I had some help here from our friends here at the firm and my colleagues, and I don't know what I would have done if I didn't have some professional guidance. All that money and property being worked through, my concern of missing something if I didn't have some guidance would have kept me up at night. But so I'm glad that I had some help. So we have about 70% of the people having cast their choices here. We have 15% say I have been the executor of an estate in the past on my own. 5% say as an executor I sought professional guidance throughout. 22% say I may be asked to be executor of an estate in the future. 39% say I want to keep my planning in order to keep costs down. And 16% say I'm an advisor here to learn to better serve my clients. So there you go, Steve.
Very good, Jeff. Much appreciated.
Steve, I'll make you the presenter here.
Glad to get to know who is on today as our special guests. Thank you, Jeff. And I'm going to get our presentation up here, get the slideshow started. Bear with me just a second. And good morning, everyone. And again, thank you, Jeff, for that wonderful introduction, and happy Wednesday to everybody. And I just wanted to start off by saying thank you for supporting our webinar series. Without you, we couldn't do this. And without my staff and attorneys here, and Jeff, my colleague of a long time, if he wasn't here to help me and be the moderator today, we couldn't do what we do. So thank you, Jeff. And it looks like we've got another moderate day out there. It's pretty cold, so we're just going to strap in here, and wherever you are in the world today, Maryland or not, we're going to focus today on getting you some guidance and substantive tips on how you can deal with and think about administration. And before we do that, I just wanted to remind Jeff, you know, Jeff, I brought my glasses as well, and I was noticing, although I don't see you right now, that you had, you know, maybe a light blue on today instead of purple. So I'm really sorry about your team on Sunday. Are you doing okay about this, Jeff?
Well, Steve, we don't have too much time, but there's football Jeff and there's non-football Jeff. And I've set the football Jeff aside and I'm focusing on non-football Jeff right now.
I got you. Gotcha.
So we'll just leave it at that for now.
At least do the Super Bowl. Well, I'm really sorry about your team, but anyway, very exciting football over the weekend for you football fans. Well, anyway, as we get focused back here on the webinar, thank you for your support again today. We know that many of you, you have great concerns right now that may have driven you to come and spend your time on a Wednesday morning with us. And it's a very busy day. We're going to be efficient. And you might have experienced loss recently. You might have some special concerns about someone who has an illness, and how are you going to deal with their estate and so forth. So we're here to help, we're here to guide, and we're here just to really have a conversation. So let's do that today. And as we get started, I'm going to further extrapolate on Jeff's poll, and we'll take a few minutes to just, you know, further think about why we are here today and kind of gear up for the discussion. So again, thank you for being here. We look forward to helping be through the work through the presentation today with you. And as we do that, obviously this is not legal advice that we're able to give by a webinar. So we are not in an attorney-client relationship for anyone who's on this webinar. And we know there are various people here for various reasons, but we could enter into an attorney-client relationship at another time. So this is very high-level material and it's very educational in nature. So we're going to be talking about what is administration, what is estate and trust administration in a nutshell, basically. This is a vast subject and it encompasses all kinds of law in the various states. And it encompasses intestacy law, and it encompasses tax law, and there's transition of business assets. It's a very, very broad subject, but we're going to try to bring it down to size today to where we are and how to deal with it. In that process, I'm going to be talking to you about a couple of checklists that we have, and you've been sent these checklists. One is for administration, one is for trust administration. So we have estate and trust administration checklists that we're going to be referencing throughout. We're going to talk about the mystery of what happens when someone dies, and this legal mystery, I should say, that is about how do we move forward after someone has passed away. We want to minimize the confusion and talk about support of family members. And I'm going to give you some examples of the various types of situations that we run into, that you could run into. And we're going to talk about a legal process. One of the things we're going to talk about is not only these checklists, but we're going to talk about process. One of the greatest things that I could leave with you today is that estate administration or trust administration should be seen, like estate planning, should be seen as a process. So when we engage in a process, then we kind of eliminate mistakes, we eliminate randomness, we eliminate a lot of the bumps in the road that we would otherwise run into if we did not have a process. So we're going to talk about the process at death. What are the practical steps? We're going to get into those things. What are the significant legal and tax issues? Not just the process, but what are the things that we really should keep in mind? Not that you're going to remember all of this, but you're going to use it as a tool, and you're going to realize that there are certain things that are more significant than others, although there is an overall process. We're going to talk about how advisors, professionals should work together and how they can work together in the best interest of clients. Now, many of you on this webinar today are what I would just call people who are special guests, who are interested in learning. Maybe you are past clients of our firm or another firm. And many of you are financial advisors or CPAs. So this presentation is geared around both sets of the audience. And so before we get into this first slide of unraveling the mystery, I thought that maybe we would take about 2 or 3 minutes, which in the world of video and webinars and so forth is an eternity, 2 or 3 minutes. But I wanted to really slow down at the beginning and really give you a chance to take your tablet, whether it's a physical tablet of paper or whether it is an electronic tablet, your iPhone, your computer, whatever it is that you might use to make notes today. I'm going to give you an opportunity to really think through some questions. So if you will indulge me, I am just going to extrapolate off of Jeff's prior poll, and I'm going to start by asking you some questions that I hope you'll entertain. We're going to take about 2 or 3 minutes on this, and I've set my timer. Here we go. So I'm going to just ask, what is your interest in administration? Now, Jeff kind of asked, what has brought you here today? But I want you to really think about, what is my specific interest in this? It's a very broad topic. Have you administered a trust or estate before? And some of you said yes. And I'm going to ask, what were your impressions, or what are your impressions, okay, in this process, or in that process that you went through? What was your experience? And do you have any stories that you wish to tell? Now, obviously, we have a limited amount of time today, and you are pretty much limited to the chat box here on the webinar. But if you have some stories to tell or some input, we really would appreciate your input in the webinar. It helps a lot of people on the webinar. Have you had experiences that were positive or negative about administration? And again, What are your greatest concerns when you think about this? Do you have confidence in your fiduciary, the person that you've named as your personal representative or trustee right now, that they could carry out and administer your estate? Have you thought about whether there should be an independent fiduciary to administer your estate? What are the resources that are available to your loved ones? I know for many of you, this is going to be the greatest question about administration, and that is, who will be there for my loved ones? We know with a lot of our Elville and Associates clients, this is the greatest concern. Will my loved ones be supported after my passing? How can harmony be maintained between beneficiaries and loved ones? And hopefully harmony exists now and hopefully in the future. How can that be continued and maintained? Are there any nuances about administration that should be addressed in your own planning? Are there certain things that we can just anticipate that we should be anticipating in your planning that will ultimately show up sometime in the administration? So we want to address those issues. And what are the most important things to you when you think about trust and estate administration overall? So I just wanted to take a couple of minutes here at the beginning. We have about 30 seconds left. Really go under the hood, so to speak, under the surface, and really ask ourselves, what is this thing that we're most concerned about so that we get the most out of this workshop today? And also, we just really appreciate your participation if you have any questions and so forth as we go along. All right, we're going to do about another 10 seconds here, and then we're going to launch right into the slides.
Can I go ahead and pose a question to you right off the top here,
Go
Steve?
right ahead, Jeff.
And the question is, can an executor be a family member?
Thank you for that wonderful question and for starting us off in the right direction. The answer is absolutely yes. A family member can be the personal representative and usually is. Thank you. All right, let's get right into this, Jeff. You'll stop me at any time. So when we unravel this mystery, okay, we know this is one of the greatest concerns of clients, as I just mentioned. In a will-based plan, we're going to have probate, which is the probate process, which is proving the will to be valid. That's really what it is. But it also is possible to have probate when there's no will, and we're going to see that today in one of the brief examples. Trust administration, there is still a process. Under the will, with the register of wills, let's say, there's a process. In trust administration, even though it's private, there is still a process, okay? And then we're going to talk about a transitionaries period. This is one of the biggest questions that people have. When I die, what happens after my death? Not only will my family members be supported, but what actually happens? And this is true especially with a revocable living trust. And remember, a revocable living trust is an alternative or substitute for a will. So when we have a trust, hopefully that trust is fully functional and fully funded with our assets. And then when we pass away, whoever passed away, that trust has to be administered. And that transitionary period, that administrative period, from the time that someone passes away until the time of distribution, this is one of the greatest mysteries or questions that people have. So we're going to be answering that question today and really talking about it. Who will be there for the surviving spouse? Now, the surviving spouse, if you're married, or children, or nieces or nephews, or others, who will be there for them to support? And we know some of you maybe on this webinar today have lost loved ones recently. Our sympathies and condolences go out to you, but just know that there is support available either through Elville and Associates or other competent lawyers that can help you with administration. So a lot of people say, what do I do if I'm a survivor? For example, this morning I spoke to a surviving partner. This was a life partner and not a spouse, a person who by all purposes might as well have been a spouse. They were together for over 30 years. What do I do at this time? Should I be driven by process? And the answer is yes, you should be driven by a process, not by circumstances, not by randomness. And then if we are still the people who are still living, fortunately, and we have control of this future process, we want to do that control through planning, education, and organization. And that is where we look to the handouts, We also look to our own estate planning. And if we are the fiduciaries for someone else, like parents or other relative, we want to encourage them as much as possible to be organized so that our job as fiduciaries is as straightforward and process-driven as possible. We're going to be talking about certain case examples this morning. In addition to being redundant, you'll notice that I will say things more than once on purpose to try to drive this information home to you. We're going to be talking about certain situations, and it's so vast, the different situations that can occur in planning and estate administration. Some of them, there's a clear plan, everything is clear, and the process is clear. Other types of plans may be pretty clear, but the assets are such that the way the assets are titled and so forth, it's more that those assets are driving the process, and we're focused on getting our arms around those assets. Sometimes there's a specific need. There's a survivor situation where someone's vulnerable, or someone doesn't have a place to live, or other beneficiaries are not getting along. The survivor situation could be different, or it could just be challenging. And then there are other situations where there's just poor planning, no planning, and there's certain judgment calls and gray areas that have to be addressed. So we're going to be talking about a few of these things, but the main thing that I want to, again, drive home to you today is that if you find yourself in a situation where you have to administer a trust or estate, there is a structure. And in the trust side of the world, there is not such a clear structure because the trust-driven plan is private. So we have to kind of understand that even if we have a private plan, a trust plan, that does have a structure that if we are a fiduciary, we need to understand that structure. And that's the credit to you today of being here and trying to learn what that structure is. So we're going to talk about a few fact patterns here. And we're not going to be so focused on these. I have done these webinars with Jeff for years, and sometimes we really focus on these fact patterns, but I'm just going to give this to you in a general sense because I really want to know your thoughts as we go through. But here is an example of someone who died, who was a single older man, and this person died in a very straightforward situation. He has one child, an only child. And this person owned a residence. They had checking and savings and CDs. They had savings bonds, which do go through probate. They had an IRA, which in this case, we have to assume it was properly beneficiary designated. So this should be pretty straightforward. He made no lifetime gifts. There's nothing really complicated. He had $2,300 a month in Social Security, and he had a will. This person had a will, and he left everything to his child outright. So we're going to look at a few nuances of this. One of those is the savings bonds. That savings bond situation, even though those savings bonds are not taxable until death, because he held them until death, they are part of his probate estate if they were not joint. The IRA has to be claimed by the son. The son has to get appointed as a personal representative of the estate to take control of these things. And as you look at your checklist for critical dates, you'll notice that there is a certain process here. This particular gentleman had a date of death, and then there has to be a valuation of the assets and so forth. And this is what we would be calling a regular estate because this person died with significant assets in their name. So we just want to kind of be familiar with different fact patterns. As we look at the second fact pattern, if we have time, we're going to come back to this. This is a married couple now, and if we look at the bottom of this slide, we see that they have a revocable trust. Remember that when a person or a couple comes to do estate planning, they are either going to develop a will-based plan or a trust-based plan. Here, this couple developed a trust-based plan. They have 3 healthy children. They have a residence. They have a brokerage account. They have retirement plan assets. They have checking and savings. They have but look, they have a second residence, okay? So everything here is pretty typical. They have normal assets, as we might say, and we have to assume those assets are properly titled in their revocable trust, but they do have an out-of-state property. And that was their Delaware residence, which many people have a Delaware residence or a Virginia residence or a Florida residence as a second home. And this happened to be titled in the name of the trust. They made no gifts during life, and they had a straightforward estate plan. Everything was outright to the surviving spouse. So as a fiduciary, we would look at this, and we know that there is a surviving spouse, and that is Janet in this case. Now, when there's a surviving spouse and everything is outright to that spouse, this is a pretty straightforward situation. She's going to take control of the assets. Everything is going to be retitled to her outright. She's going to make death claims on the IRAs and any life insurance. And this is a pretty straightforward situation, but we're going to look at what? We're going to look at the critical dates checklist for a trust. But with that said, even though there is some administration here, this administration is private because it's a trust. Everything was properly funded, and this surviving spouse is being supported in this example. It appears she is. And she's healthy and well. Now notice at the bottom of the page, if this had been a more complicated estate plan where there was not outright distribution to the surviving spouse, there might have been various types of disposition formulas between the spouses. This could have been for estate tax planning. This could have been for other reasons of marital control or asset protection. So if a trust contains a formula or various types of structures about how the assets will go between spouses or not, based on various control mechanisms, you as a fiduciary need to evaluate that right from the very beginning. So here, do we have an estate tax problem? Well, if we added up all these assets just at a glance, they would be less than $13,610,000. So that is the current estate tax exemption for any person on the federal level. But the estate tax exemption for Maryland is $5 million. So we know that the first spouse died and left everything to the survivor here. But what do we know the survivor has? The survivor has the right to elect to use the exemption amount of the first spouse. These are things that you need to be aware of if you're a surviving spouse or the fiduciary for a surviving spouse and you're helping the family. That surviving spouse can make the portability election, which means they can utilize the exemptions of the deceased spouse if they haven't already been used. And now that spouse has his or her own exemption plus the estate exemption of the deceased spouse. So these are the nuances and the vast number of things to consider that we have to be aware of when we're looking at a fact pattern like this for a surviving spouse. And if you don't remember all that, do not be concerned. The thing I'm trying to drive home here is that you're looking at the type of assets, you're looking at the date of death values, you're looking at whether the surviving spouse here will make tax elections, and hopefully she will, because that's going to be a judgment call on the death of the first spouse. Now, what do we know about the estate tax exemptions? Not to spend too much time on that. We know that they may come down on January 1st, 2026 to half of the current levels on the federal level, adjusted for inflation. So those exemptions could be around $7 million per person instead of 13.6 per person. And the Maryland exemption may or may not go down at that time. So we have to keep our eye on this and know what the applicable law is at the time of the first person's death. This fact pattern 3 is the similar situation to what we just looked at, except now the survivor has died many years later, and now one of the children is disabled. So here, she has sold her primary residence. She was living in a continuing care retirement community, so she has a deposit there. Just to go over this fact pattern very quickly, she has a large IRA at this point. She has a larger brokerage account. And look what she did. She sold the Delaware house and decided after her husband's death to buy a house in Florida. So she was very much living her new life. And now she has passed away. We have to assume that there were plenty of funding of assets in this trust, that the Florida residence was in the trust, that the CCRC deposit is designated to the trust. We'll just kind of make those assumptions. And now we have a death of a surviving spouse. So now the surviving trustee has to step into the shoes of the deceased spouse, and they have to administer this trust. So this is that situation where even though it is not an estate, this is that transitionary period. the survivor has died. Now the real administration of the assets is going to take place as they get ready to be distributed to the children. Now, there is a possibility that this one particular child who's disabled would need special treatment when it comes to the distribution of assets. So you as a fiduciary would look at this and say, well, gosh, the responsible thing to do and the thing that is commensurate with my fiduciary duty is to distribute these funds to a special needs trust, perhaps a supplemental needs trust for this brain injured child that no one anticipated would be brain injured. And the surviving spouse who then died, she did not address this issue. So this fiduciary can address this issue. And if assets were going to be left in further trust, perhaps that trust for that disabled child could be decanted or changed into a different type of trust, or perhaps the planning itself provides for a supplemental needs trust if someone who is going to receive assets is disabled at the time of the survivor's death. So just a lot to consider here: estate tax, making sure people are getting notice, which you're going to find out about, making sure that all the assets are accounted for. This is part of the idea of what I want you to walk away with today, is that administration, whether it's an estate administration or a trust administration, is a process. Here is the disaster scenario. This is the scenario where someone has died and he was still married but separated. And we won't get into the seediness, let's say, of this particular situation. But here's a person that maybe more often than not is representative of the fact that many people, most people in the United States, do not even have a will. So here we have a situation where someone dies, they are married, they have no will, the surviving spouse is entitled to a certain amount of assets by the intestacy laws. There are all kinds of logistics going on here, and we just have to be aware that there are a lot of nuances here, and that there would be probate even though there is no will. And notice that one of the children is in bankruptcy. So when that child gets their share, there's probably no way to protect that share except to distribute it to the child, and that child may possibly lose it to a bankruptcy creditor. So here there's just lots of negative things that happen because there was no planning. So when someone dies, obviously, go ahead, Jeff. It sounds like we
pause for a few questions before we jump into that next part. All right, great. Thank you so much. First question is, do you always have to probate if there is a trust?
Thank you very much for that question. The answer is yes and no. If there is a trust, and that is a revocable living trust, which is a substitute for a will, we have two things we're trying to accomplish: the best design and implementation of that trust, and also a full funding of that trust, meaning that all of the person's non-retirement assets, not IRAs, not 401ks, all of the non-retirement assets are properly funded into the trust. If that occurs, then there needs to be no probate. Sometimes there is something that by circumstance might be hanging outside of the trust, like a vehicle or a small checking account, or maybe a brokerage account that never got titled in the trust. We don't want that. That's not good planning. However, if that were the case, you would have a trust administration and an estate administration. But if the proper planning is done with that revocable trust, there should be no estate.
Okay. Next question, have a scenario. When a decedent has a will and the agent goes to probate, the decedent has all assets in TOD/POD investments. So the only probate items would be a car and a bank checking/savings account. Your thoughts?
Yeah, I think that's exactly right from what I heard. In that scenario, there's nothing to probate, maybe tangible personal property and so forth, but there's nothing significant to probate other than those two accounts. And then what we have to ask ourselves during the planning process is, do we want to, not at death, but during the planning process, do we want to rely on TOD and POD, transfer on death, payable on death, as the sole means of transferring property from point A to point B? because that does not provide any flexibility for some of those changing or unknown circumstances that we just kind of went through there briefly on those 4 examples. So that works exactly the way you just said, if everything works out perfectly. So what wills and trusts do is they account for the possibility of things not working out perfectly and having alternatives in how we deal with things should things go off the rails.
Okay, and last question for now. If savings bonds have a beneficiary, is there probate?
Oh, thank you very much for that. The answer is no. So if those savings bonds have a beneficiary, then there's no probate. It's only if they don't, and this is one of the first things I learned in my young legal career long ago, is that savings bonds have significant tax that's due, and those taxes have to be allocated properly, either among the beneficiaries or the decedent's final tax return, or to the estate and the estate's tax return. So yes, but in your example, there's no probate.
Okay, thank you.
Thank you, Jeff. And thank you everyone for participating. So we want to have empathy for our client if we're professionals, or the fiduciary and that situation in the family. We want to make sure the family support exists or that it's provided somehow. There is a great deal of support out there through the various professional networks, and I would say the web of professionals, including life care managers, attorneys, CPAs, financial advisors, life insurance specialists, advocates of all kinds. So people who are in need of counseling or support, those resources are available. If you are a professional, your whole firm should be aware of this and be empathetic towards that situation and be resources, and I know many of you are. We need to be creative about resources. I have recently seen situations where life care managers were extraordinarily powerful in the support and the difference that they were making in people's lives. So I cannot say enough things about the life care managers out there right now and what they're doing, especially a few of them we're very familiar with at Elville. And we want to have the ability to refer and be a counselor and coordinator, not only for the fiduciary, or if we are the fiduciary or advising the fiduciary, but for the family overall. We want to assure the fiduciary that they should take care of themselves first. I know many of you have seen this. We see it here at our law firm many times. There's a survivor, usually a surviving spouse, and that surviving spouse is sometimes in a hurry to get things taken care of. There's a sense of urgency. And sometimes it's just too soon. And we want to just give the survivor, especially a surviving spouse, the permission to be methodical and take care of themselves first. Sometimes there are urgent issues like real property, like investments or in rental properties, and there's weather and there's freezing pipes and there are things that have to be taken care of right away. But generally speaking, a surviving spouse can be methodical with the advice of their professional advisors and take care of themselves first, and then address the more serious issues. We want to assure people and survivors that the advisors are working together. That's one of our themes in 2024, as it was throughout 2023. We want our clients and their families to have collaborative teams of advisors that are not only just there, and they're there to render their professional services, but they are actually talking to each other. We want to assure them that things are in order, and if things are not in order, we want to make sure that they are methodical and as process-driven as possible. Funds need to be available, and if the funds haven't been particularly well planned for, we need to find creative ways of making funds available. There is flexibility even among, I should say, an estate administration situation where there doesn't seem to be a lot of liquid funds that are available for the people who are surviving. There could be a surviving spouse with minor children. There could be situations like this, and these things can be worked out, generally speaking. We want to assist with final arrangements and make sure that we're really taking that seriously, because that is a very, very big thing. And we want to deal with any family-related issues. If you're in a family where everyone gets along, you are very blessed. Sometimes after a death, there are problems with family members, and we want to kind of anticipate those. And we want to show our condolences as professionals and as people to attend funeral or other memorial services and provide the proper sympathy expressions. So there's a legal process, and let's talk about that now. And what is that step-by-step process? Well, let's talk about probate versus non-probate. We've been talking about wills. We've been talking about non-wills, revocable living trusts, generally speaking. These have similar steps. Remember, I said both need to have administration, even though the revocable trust is private. We want to use those checklists, and again, being redundant, we want to be organized. So this is a very broad brush, and I also want to just say again that there is no one overall presentation that could encompass all aspects of estate administration or trust administration. And there are different types of administrations. There are small estates, there are regular estates, there are modified estates. I'm going to talk as if this was a full-blown regular estate. This is just a general overview. You do not have to remember all of this. Of course, there's a date of death and a death certificate is going to be issued. That is the beginning of everything. Then there are letters of administration. These are the official documents that allow you as the personal representative. Some states call that the executor. It allows you to take charge of the assets. Then there's an inventory due, an information report due. The Register of Wills is going to want to know how much is in this estate. When we opened this estate and it was a regular estate, we didn't have to tell them everything about the values and all of the assets. But when we get to this point of the inventory, we need to know what the valuations are. So we had to get appraisals and we have to understand the values. And then the information report tells the Register of Wills, is anyone in this estate subject to inheritance tax? So remember that Maryland is one of the only states that still has an inheritance tax and a state estate tax. So we have to deal with this inheritance tax and let the Register of Wills know, is anybody subject to inheritance tax, because the Register of Wills actually collects inheritance tax. Then there are alternate valuation dates, and those are not something we use every day, but it's available to us. Claims against the estate. Creditors have a claims period of 6 months. We have to address that. And there's notice to creditors that many of you have seen in the newspapers or now on the online papers throughout the years. The spousal election. The spousal unit, the survivor has the right of election. So we have to address that, especially the new spousal elective share law. If the survivor is not getting enough money from the deceased spouse, surviving spouses are protected under the law. Disclaimers, these are types of tax planning, or there could be another reason why a beneficiary disclaims property. Well, for purposes of the federal estate tax, this has to be done within 9 months of the date of death, so we have to be mindful of that. And the federal estate tax return and the state estate tax returns are due within a certain period of time, as well as other elections have to be made for taxes within a certain period of time. And one of those elections, as we go to the next slide, is the Q-tip election. And I didn't make that up, but it's qualified terminal interest property is the meaning of that acronym. And that is an estate tax election. And so we have to, or an election, I should say, on the estate tax return. The portability election, especially for those people who have higher assets, higher net worth, when the estate tax exemptions come down, if they come down in 2026, this is going to be making it more expedient and more very, very important for many people who are currently on the fence about whether they should make a portability election. And I'm in favor of many, many types of people making this election to lock in the exemption amount of a deceased spouse. But it's not right for everyone. It does mean that an estate tax return has to be filed. So when we have a surviving spouse, we want to make sure we're really thinking about this portability election and whether it needs to be made or not, and make it timely. The first administration account is due within a certain period of time, usually 9 months from the time the estate is open, and subsequent estate accounts have to be filed in certain periods of time. And then by the time that we get to the time of the final administration, there's going to be a review of the final accounting. Retirement plan accounts have to be procured or the death claims have to be made on time. There's a certain time period for that. If you're not familiar with that, the time period where we really start having to worry about making these death claims on inherited and rollover IRAs is really the fall of the year following death. So if a person died in February, a person would have until the year following death, the fall of the year following death, before a certain periods of timeline start to occur where this timeline has to be adhered to for the survivor to get an inherited IRA or other IRA. We have to bear in mind the effects of the Secure Act when we are helping beneficiaries be able to take their death claims on these assets, and how the assets are either exempt under the Secure Act, meaning that the assets can be stretched out for the entire lifetime of the beneficiary for tax purposes, or whether, like most people, the beneficiary has to take the tax within 10 years. We have to be concerned about estate tax returns for the estate or trust itself. And here we're talking about estates, and those have to be done. Those are called Form 1041s. Those have to account for the income that is attributable to an estate. And we have to make sure the decedent's final tax returns are filed. We have to make sure, if we're dealing with IRS for any open taxes, that we have a closing letter, especially in estate tax situations, and so forth. And I'm just going through this checklist as quickly as I can. And that concludes, for example, a very quick tour of the estate process when we're dealing with a checklist or the critical dates for an estate, generally speaking. Now, those are not all inclusive, but those are generally giving you a very broad overview.
Steve, can we go ahead and pause for a couple of questions with that in mind? Okay, thank you. First question is, under a will, how would you specify that agent can be paid for work as an executor?
Thank you for that. Nice question. Well, if you don't say otherwise, your personal representative is entitled to compensation by statute. Now, the statute, the way it articulates compensation is a bit counterintuitive, but basically here is the formula. For the first $20,000 that's in probate, the Register of Wills or the Orphans Court allows $1,800 of compensation. And then for everything above $20,000, the total compensation without court approval, or the total fees, I should say, that can be paid in an estate, are 3.6% of the amount above $20,000. Now, that formula, when you add all that up, is about 4%. Now, the problem there is your fiduciary, your personal representative, you want them to be paid. That personal representative, if they handle everything themselves in the estate, that's not going to be a problem. Usually, they're going to be able to petition for those fees and be paid those fees. But many times, a personal representative needs professional help. They're going to hire a CPA. They're going to hire an attorney to help them administer that estate. And now the way the court looks at that is that 4% roughly, that has to be shared among all these advisors or all of these professionals that are being paid. So what you're going to be concerned about there is you want your personal representative to be paid. However, they might not be paid if the other professionals are taking those fees by necessity. So you could articulate in your will that even though statutorily the person is going to be paid, theoretically, that you want to set aside a certain amount that this person would be paid no matter what, the 4% that is allowed by the court, no matter what that encompasses. So that's how you have to think about it. I hope that's helpful.
It is, thank you. Next question is, likewise for a durable POA, can agent take compensation? Is it sufficient to say, quote, agent may be compensated for work under this durable POA, unquote?
Excellent question. So now we're getting a little bit away from administration, but that's a great question. Thank you for that. Back during lifetime now, your agent was, you created a power of attorney. You are the principal. You gave your agent the authority to act for you, and you said, my agent may be compensated. So the answer is absolutely, they can be compensated. And I think the only thing I would do in that particular situation is I would be a little bit more specific about how much they can be compensated because that probably means they can be compensated by what I might say is reasonable compensation. What would a reasonable person be paid? Some people would say, well, I should be paid at my own rate because I took time off of work to take care of this person who was the agent. So it's really just a question of setting forth how much reasonable compensation might be, or you could leave it the way you've got it there. But that is going to authorize them to be compensated.
Okay. And last question for now, what happens if the time for filing for probate was not done in the time frame you just gave?
Well, thank you for that, because I took away from that question the first part, which says, what happens if the timeline for opening probate, I think is what you said, and there is no real timeline. So that's kind of the mystery of it a little bit. I think that if someone passes away in a reasonable period of time, the person who's named as the personal representative in the will should petition the court to open the estate and submit the will for probate. If there is no will, then there can be what is called judicial probate, and that means that an interested person can petition, and then with the consent of everyone, or with a hearing before the court, someone can be appointed. So it's really just a question of what is reasonable, in my opinion, and whether there's a will, and whether that will names someone that's very clear. They need to come forward and probate the estate, generally speaking, in a reasonable time.
Okay, thank you.
Thank you. Thanks everybody for making our presentation so interesting by your questions. Now let's look at the process that happens at death in a non-probate situation. And what I mean by that is if someone used a revocable living trust as their vehicle and that revocable trust was fully funded. Now maybe there's retirement assets over here and we know they don't go into a revocable trust. But what I'm illustrating here, don't have to remember all of this, is that there's still a process. Let me give you an example. If someone passes away and they have an only child, and that person has a revocable living trust, that's one of the most powerful situations in estate planning, in my opinion. When that person dies, that only child can take those assets almost immediately. They have no one to account to, no one to worry about. But even in that situation, they should be mindful of some of these things. Final tax returns, and there should be at least a mental process, a mental checklist. But let's say someone dies with a revocable trust and they have 2 children, 3 children, 4 children, or nieces and nephews and charitable gifts and other things. Well, now, even though there's no probate, mentally, we still want to think if we're a fiduciary, we have a fiduciary obligation to administer that estate, that trust, excuse me. And we want to walk through that process because why? We want to be transparent. We have fiduciary responsibility. And we want to make sure what? That we are released from liability when we have done our job. So let's go through this quickly because I'm running a little bit behind through no fault of yours. We want to still know what date of death values are. We have to know that. We have to know that. If there's a taxable estate especially, we want to know that. We have to know that. Notice to beneficiaries has to be given. So since 2014 in the Maryland Trust Act, beneficiaries have to be notified, qualified beneficiaries. Even the creditors can be notified. In a revocable trust, creditors could make a claim. Now, I personally have never seen a creditor make a claim against a revocable trust, but by law, you as a fiduciary could run a notice to creditors and foreclose creditor claims after a certain period of time. The alternate valuation date still is applicable. The spousal elective share is actually in place in Maryland. Jeff, we need to fix this slide. And we do have a new spousal elective share. And this has been around for a couple of years now. So we have got to think about this when we are administering an estate. If we have a trust, if we have assets going to the surviving spouse 100%, we don't need to worry about this at all. If we have less than that, basically going to the survivor, maybe someone who passed away left assets to their children, left assets in a way that it does not all go to the surviving spouse, or there's a disability. One of the spouses is disabled, and maybe by design, the assets are going into a supplemental needs trust. We need to be aware of this spousal elective share law. So if you have a hard copy of this in front of you, you need to make a note on this. We apologize that there is a new spousal elective share in Maryland, and we want to make sure that we are addressing that. The Q-tip election, that marital trust election, we have to think about that. We have to think about portability, disclaimers, federal and state tax returns, the retirement plan accounts, we have to be aware of those. The Secure Act, we have to be aware of. Let me give you a little tip that has to do with IRAs. Let's pretend that you were a fiduciary of a revocable trust. You're doing a great job doing your administration, and you did a great job. You helped the beneficiaries take their inherited IRAs right away. And those inherited IRAs were significant. However, in your case, the beneficiaries of those IRAs were subject to inheritance tax. Let's say this person had no children. They left everything to nieces and nephews, including those IRAs. Well, just remember that when you assisted, and your job is just to assist, that person has to make their own death claim, basically, for that inherited IRA, in so many words. That person is subject to 10% inheritance tax when they take that IRA. So you as a fiduciary, you just want to keep in mind that even though you continue to administer the trust for maybe quite some time before it's finally distributed and before the final inheritance tax is paid, you want to make sure that the Register of Wills in your particular county is probably expecting to be paid on those retirement plan inheritance taxes as soon as those are secured by the new beneficiary. When we are dealing with a revocable trust, remember I said when you get to the final administration period, you want to be released. We spoke to some fiduciaries this morning that are working through the final phases of an administration, and we are going to get ready to distribute those assets now. But before they do distribute those assets, they are entitled to ask the beneficiaries to sign a release and a waiver and even a refunding agreement that says we have been transparent, we have done our job, and you release us from liability before the distributions are made. And as you can see, all of the other normal considerations about tax returns and everything apply to a trust. So hopefully what I've driven home here in this presentation so far is that there's an estate administration process, there's a trust administration process, and no matter which one we are dealing with, we still want to be mindful that there is a process, and a good fiduciary is going to be mindful of this, and you're going to be thankful in the end that you did follow the process, because not only the satisfaction of doing a wonderful job, but and doing what your principal asked you to do, but also because you're going to feel that you were tremendously transparent and you did a great job for your beneficiaries that are going to receive the assets. What are the practical steps that needs to occur? Now, we talked about the legal steps. What are the practical ones? Again, give the surviving spouse, if there is a spouse, if there is a surviving partner, give them room to breathe, unless there is an emergency, which there could be. But unless that happens, give them time to grieve, support them, coordinate with other advisors. If you're an advisor on this call, collaborate with your team, and many of you do a great job of this. Nearly all of you probably do. And make sure that your client has a team so that that team can coalesce and collaborate at a time of crisis. Make sure that we're using a critical date checklist. Again, I'm talking about real fundamentals here. We were talking about football, just being fun, having fun there at the beginning of this, but really this is the fundamentals. It's like the football drills, or it's the basketball drills, or it's the baseball drills when we were young. And you know, we're out there as athletes or young athletes out there playing these games, but we are drilling in the fundamentals, and that's what we always want to keep in mind. Organization and the fundamentals are the key to success. We want to have, generally, in my opinion, an inclusive process. Now, what that means is that not every family gets along. Not every situation is a nice or rosy situation. And beneficiaries are entitled to information, not only in an estate, right, especially in an estate, but in a trust, beneficiaries are entitled to information. Qualified beneficiaries are entitled to information. So we want to bear this in mind. You know, many people have an exclusive process, meaning let's give people the bare minimum. Let's protect against people who would attack the trust. Well, there's very, very good reason to be worried about that. But generally speaking, the fiduciary, in my opinion, should try, to the extent that it is reasonable and practical, to be inclusive, make sure that we're following fiduciary responsibility. For example, qualified beneficiaries are not only entitled to notice, they are entitled to information. There is no such thing in Maryland as a quiet trust, or we can keep everything secret. So there are ways maybe to limit information and be minimal, but I think generally speaking, for the greater good, it's better to have an inclusive process. Now, with that said, we can't control all situations, and there are times when being a fiduciary is just going to be downright very difficult, and it can be a miserable thing. But this is something we want to be aware of, that perhaps sharing the required information will not only protect you as a fiduciary because you carried out your responsibility, but maybe it helps us get to where we need to be with the least resistance because we're actually sharing information. So that's just something to take on a case-by-case basis. We want to do reasonable due diligence, again, to make sure surviving people are coping and that they have support. We want to encourage people to be methodical and, again, encourage surviving spouses to take care of themselves. Again, practical steps, organization and traditional readiness is key. Document storage can be traditional. Document storage can be electronic. We want to think about these things during life and so forth. And there are electronic archives. Now, when we are fiduciaries, we are dealing with people's electronic assets in much more greater depth and much more greater substance, I guess, that they exist in much more greater quantity. So we want to remember that as fiduciaries, we have the power to deal with people's digital assets under the Digital Asset Act many, many years ago. So we want to be aware of I guess, special assets such as Bitcoin and other types of assets now. So this is part of the whole thing, is the fiduciary responsibility and the methodical approach. Now, what are the most problematic legal and tax issues? We talked about the legal process. We talked about the practical process, but what are the most significant problems and issues? Well, we want to review asset titling prior to death. A nice person who had asked the question here on the webinar today about TOD and POD, they were really bringing up a big issue. And that is that you want to make sure that this titling is by design, right? What if I have a great estate plan? I had done a great deal of planning for this will or trust, but I use TOD or POD. Well, obviously my trust or will is not going to control those assets. Those assets are going to pass by TOD or POD. If we're going to use those things, those devices, we want to make sure that we're being intentional about it. Many people are unaware that they have titled something as TOD or POD. So we just want to make sure about asset alignment prior to our death. If you are a fiduciary for someone who is suffering an illness, or you don't think their longevity is that long, you want to look at titling now in advance and make sure you're doing everything you can to get that titling the way it should be. So there's continuity, peace at the harmony at the time of the person's death, and that assets are not flowing in a way they should not be flowing. Again, maintenance and updating of estate plans during life can kind of resolve a lot of this. Valuations of assets after death. We want to make sure we're getting valuations properly. We want to caution to not retitle assets quickly. We see many surviving spouses or even financial advisors who are working with their clients, and they tend to retitle assets very quickly after someone dies. Well, we just need to bear in mind that there could be reasons in how the estate plan is structured. There could be reasons for estate tax. There could be reasons for asset protection and many other things, that the assets should not be retitled without a collaborative effort of looking at the documents. How should assets actually be retitled? Where I'm going with this is that sometimes someone dies and they have an intention of how assets are to flow to the survivors, and maybe those assets are to be held in further trusts, and the assets are retitled outside of the trusts, even though the person was very, very clear about what they wanted. And this really happens through a lack of collaboration. It happens because the fiduciary doesn't read the documents or is not following those documents. So this is something that really does happen, and we want to make sure that it doesn't. Inheritance tax, I mentioned that situation where inheritance tax can come back to bite the fiduciary. So we want to make sure the inheritance tax is being addressed up front. If we know people are going to be subject to inheritance tax, we want to address that. Now, thank goodness in Maryland, most of the beneficiaries in a typical estate plan are not going to be subject to inheritance tax, meaning spouses, lineal descendants, and so forth. But people, with some exceptions, people that are more arm's length, nieces and nephews and others are going to be subject, friends are going to be subject to the inheritance tax. The good news is the Maryland inheritance tax offsets the Maryland estate tax. So there is some silver lining there. But again, we have to deal with this issue of inheritance tax if you are leaving assets to someone subject to inheritance tax. The portability election, this has to be addressed in the first few months after someone passes away for a surviving spouse to decide, is he or she going to make this election to port the exemption amount of the deceased spouse? And again, this is a very serious thing because the federal estate tax is 40%. The state estate tax is maximized at 16%. Marital elections, such as the Q-tip election, those things have to be addressed in a certain period of time. Failure to foreclose creditor claims. Now, many times we advise people who are administering revocable trusts to go ahead and notify creditors to make that creditor notice known in the newspaper, even though there may not be any real potential for creditors, just because that might be a best practice. We don't want a creditor to be able to make a claim because we didn't foreclose creditors. And that's a difficult thing to do because most of the time people don't have creditors, and now we spend that $300 or $400 or $500 on the creditor notice for nothing, basically. But it is a best practice that we want to be aware of as a fiduciary. Now, how can financial advisors, CPAs and attorneys and personal representatives and trustees and all of the collaborative people involved, how can they best work together either before or after a crisis? Well, we talked about this in 2023 and we proliferated it now into 2024. We believe people generally, clients generally should have a collaborative team, a financial advisor, a CPA, an estate planning attorney, a life insurance specialist, or a long-term care specialist, or a life care manager. We want this team to be complete, and we want the team to really be coordinating. And there should be a quarterback because, as you know, when you have several people trying to collaborate, we need someone who will usually be deemed as the leader of the group. It doesn't really matter, but we want these people, even though they're in their separate lanes, we want them to, lanes of expertise, we want them to collaborate. We want them to actually talk to each other. And during lifetime, it would be a great idea if these advisors were to meet with the client together by Zoom or by other means in person, and not only make sure that the client knows that this team is talking to each other, that this team knows each other, and that the fiduciaries and children, the survivors, know, and spouses, know who this team is and that they're working together for their best interest. We want to make sure that assets are titled properly. We just talked about that. When an illness is obvious, we want to expedite meetings because as terrible as it is to say, we're living in a world today where, you know, a lot of things are happening very quickly. We're very busy. We tend to get distracted. But when we're dealing with a situation where someone is obviously ill and their demise could happen at any time, we want to make sure that we're expediting meetings, expediting discussions, expediting the titling of assets. We want to encourage people, clients, families to use letters of intent. We might call these memorandums. We might call them letters of wishes. Sometimes in special needs planning, we use a memorandum of intent. But a memorandum of intent could also be used in a traditional estate plan of a will structure or a trust structure. So a letter of wishes, on the other hand, is generally more of just a narrative about your values, your goals. So this could take the form of a one-page addition to the back of your will or trust. It could take the form of a paragraph in your trust. But we strongly encourage you to use these because in the world today, there are millions of trusts, and we encourage you to set forth your goals, values, intentions, and your expectations for the fiduciary. And that will not only make things generally better, but it will make things generally easier for the fiduciary. We want to encourage clients to use advanced organizational tools during life to make sure they are part of a maintenance program, to encourage the education of family members, to have a systematic method of how advisors work together and how there are annual or biannual meetings with their attorney. I know many of the advisors on this webinar today meet with clients either annually or even quarterly. So, this is just a question of commitment and purpose. We want to disseminate information quickly, and we want to make sure we are really focusing on client and family needs at the time of a death. And we want to instill confidence in the client and their family that this collaborative team is available, that the resources are available to the survivors. That's really what I think most clients are really looking for. Well, Jeff, despite our wonderful questions and the fact that I took 2 or 3 minutes to further kind of set the stage for people's expectations and their thoughts, we've ended pretty much on time. And I don't know how that happened, but I'm sure that it's a good thing. And I know people are very busy today. We want to be here as a resource for you as our special guests, either existing clients or potential clients, or maybe you are a fiduciary that needs guidance. We have a branch of our firm. We call it the Waypoint Fiduciary Services. And our Waypoint Fiduciary Services, LLC, is a support organization within our firm at Elville & Associates that supports trust administration and supports our estate administration department as well. And we advise fiduciaries and we service fiduciaries, and we are also just basically here to be a resource to you. If you are a person who needs to update your planning and say, well, from a perspective of setting the stage for my administration in the future and being as best as I can be, as good as I can be for my fiduciaries to make their lives easier, if we need to update your estate plans, we review documents generally for free here. There's nothing to fear, because if you're not a current client of Elville & Associates, we are here to enter into an attorney-client relationship, even if it's just for a consultation. Even if you don't move ahead as a client, there is an attorney-client confidentiality. There's really nothing to fear, and we're happy to be a resource to you. We want to review those existing documents, as I mentioned. We want to help you form a team. If you want that peace of mind that my team is going to be there for me, those resources are going to be there for my loved ones when I am not here. We're here to help you try to form that team, or to evaluate your current team. Maybe you have a partial team, and we want to help you complete the circle of that team. You have great questions. You might have more questions. We encourage you to come in and talk about those questions. And basically, with our facilities here, wherever we might meet at Elville & Associates, we want to give you the time to think. We want to give you an opportunity to decide what's important to you, and then to help you move forward with that. So I know many of you are of heavy heart this morning. You might be dealing with an illness. You might have a loved one that just passed away, or maybe you're just preparing for your own estate planning down the road. And I commend you for being here. I want you to know that we are here for you, and we appreciate you spending pretty much an hour and a half of your time with us this morning on a very busy Wednesday morning. And I thank everybody. Jeff, I'm going to turn it back to you, and I wish everyone a great rest of the week.
Well, thank you as always, Steve. And we do have a few questions to go through before we end on time. And we'll start with the first one. Always a great place to start. And first question is, who is the best leader for the advisory team that you alluded to and we work with here at the firm?
What a great and perceptive question. Well, my answer to that would be, I'll start with, maybe one of my first impressions many years ago as a young lawyer. One of the first things I noticed is that CPAs are many times clients' most trusted advisors. And of course, that's always subjective. There's many other circumstances where at Elville & Associates, for example, we work with many clients that are referred by financial advisors as well, and CPAs. So I really think it's really a subjective answer. For example, in your particular case, you might look at your advisory team that you assemble, And you might decide, well, this particular person was the driving force of that team, and I want that person to kind of lead the discussion. So whoever that is, I think that person has to have the mindset that they are the person who is going to organize or help organize the meeting, challenge people to advise the family on a higher level, and really be proactive. So I would say probably the person who is most proactive and who is most collaborative probably should be the leader. It does not necessarily have to be the estate planning attorney. I have been in many situations where a very proactive financial advisor was the driving force. So I hope that helps.
All right, next, can you explain when portability and the Q-tip elections are pertinent?
Well, thank you for that. The Q-tip election is going to be pertinent when you pass away if you're married and you've decided to leave a marital trust. Assets are going to the surviving spouse, but they're going into a controlled environment called a Q-tip trust or marital trust. So that Q-tip election is going to be necessary to memorialize that these assets are passing by way of the marital deduction into this Q-tip trust. Now, the good news is that if you're leaving assets to a marital trust, and by definition, there's going to need to be a Form 706 completed, and by definition, the state estate tax return will be completed as well. You might as well hit two birds with one stone, because the portability election and the Q-tip election are both done on the Form 706. So if you're going to do a Q-tip election, you want to make sure that your survivor is making that portability election. Now, if you're not leaving assets in a way that a Q-tip election is necessary, then obviously you don't need to do an estate tax return for that purpose. But you still might do an estate tax return upon the death of one of you for the pure purpose of electing portability. And unfortunately, Uncle Sam did not simplify that process. At one point, several years ago, the IRS was going to simplify the process of someone who survives and wants to make the portability only election, but they did not simplify that process, unfortunately. So it'll cost a few $1,000s to actually file this portability election, or file the 706, I should say, whether there's a taxable estate or not. So where that's going to be pertinent is when you or your loved one as a surviving spouse surveys the landscape after your death and says, well, should I port the exemption amount of my deceased spouse? Now, right now, that would be $13,610,000. But in 2026, that amount could only be $7.2 million if you have not used it up already during your lifetime making gifts. So my view of it is, depending on whether the person is in this category we might call the middle rich person that has anywhere from 2 to 3 million up to 14 million, or 2 to 3 million up to 30 million. If we're in that category, right, then we have to be aware that there could be an estate tax, and there would be, obviously, if you had up to 30 million. But my point is, the issue is going to be, how urgent is it for us to use the exemption amount of our deceased spouse? We don't know how much we're going to have when we eventually die. We only know how much our deceased spouse had. So it's just going to be a question of that. And to me, this is something that most clients are going to want to do, is spend that extra money to do that portability election, because Uncle Sam's, through a Treasury regulation a few years ago, said, if you make that portability election, the government cannot claw it back from you. And I look at the portability election as an heirloom. This is something you are giving your family that shelters those assets from a potential 40% estate tax on the federal level and a potential 16%. But it's going to be subjective about what is the size of the estate at the first spouse's death.
Great information, Steve. Thank you. Next, we have a couple more here. My friend has dementia. I am her durable power of attorney, medical power of attorney, and executor. Her condition is terminal. At the present time, I am managing all her finances and her care in a senior living community. Any specific advice?
Well, again, I can't advise without the full information, but that was quite a lot of information. And I think that your friend, in the condition that is happening here, has done a lot of good planning. They have provided for flexibility. We don't know how much because we want to look at that financial power of attorney and say, how much flexibility do I have here to carry out the intentions of my friend who has this terminal illness? And it may be that she still has her mental capacity, maybe she doesn't. But if she doesn't have her mental capacity, I would look to what she has told you during her life. I would look at her estate plan and I would say, while she's still living, is there anything that I could do here that I have the authority to do in this power of attorney that could help carry out her wishes, whether it's protecting assets, which there may or may not be a possibility of doing. Do I have the authority to establish another trust or a trust? There's various things that can be provided in a power of attorney. What I would recommend is that you check on beneficiary designations, make sure everything is correct, use your authority as a fiduciary, make sure you're advocating for her, as you probably are with her healthcare power of attorney. And along those lines, take a look at her MOLST form, the medical order for life-sustaining treatment, and make sure that you as a fiduciary are in agreement with what the doctor or nurse practitioner has completed for her, and make sure that all of that is the way it should be. And if it isn't, you can address it as a fiduciary. But it otherwise sounds like your friend has done a lot of good planning despite this very sad situation. And it also sounds like you're doing a wonderful job.
And last one here, thank you for the excellent presentation. Can you say a few words about how a will and trust can work together, say to avoid probate?
Well, thank you for that, for your very kind words. You're welcome. What I would say is when you think about basic estate planning, you're going to decide, is avoiding probate, the right thing for me? Some people do not care about probate. A lot of people do care about it. It's probably the biggest conversation in America about estate planning is, should I avoid probate? So I would say that if you have a lot of non-retirement assets, meaning if your non-retirement assets are the majority of your assets, then I think if you want to make things as easy as possible, so to speak, and you have a trusted fiduciary, you have someone that if your administration was private of your estate or trust, your trust administration was private, that you would have confidence that this person would carry it out without a lot of public oversight. And if you wish to, in theory, minimize fees as much as possible, then I would use a revocable trust. If your assets are a healthy mixture of retirement assets and non-retirement assets, and it's kind of a judgment call, or if you have most of your assets, like some people do today, you have a lot of retirement assets and the lesser amount is your non-retirement assets, then I think it's just a question of looking at it differently. I'm avoiding probate over here. Should I avoid probate over here? So if you have raised this question in your own mind, should I avoid probate? Well, now I think the answer is yes. You should use a revocable living trust unless there's a reason not to. And the only reason I can think of not using a trust would be you don't have a trusted private fiduciary that you can rely on, which you probably do, or you just don't feel comfortable retitling assets in a revocable trust. So if none of those things really concern you and you want to avoid probate, then I would use your revocable living trust as kind of the driving force of your planning. You do that as the first step. The second step is to fund the trust with your non-retirement assets using your own efforts, the help and support of your advisors, your support of your attorneys. Now you have a fully funded revocable trust. You don't need a will because you've got a fully funded trust. However, good estate planning is using the will as a backup, and that's why we call it the pour over will. It's a will that simply pours over into the trust. In a perfect situation, you'll have a fully funded revocable trust with no need for the will, but the will is there as a backup document. So to answer your question, I think the best way to use wills or trusts to avoid probate is to focus on the trust if you have no other problems with any of the other things I've pointed out, and then use that as your driving force. Only use the will as a backup, and look very carefully at, do I have all of my non-retirement assets in my trust? My retirement assets are outside my trust, such as life insurance and IRAs and 401ks, and annuities generally would stay outside the trust. But once you have all of that aligned, now you have a plan that will actually work.
Steve, thank you very much. It sounds like that's something you've said before.
I think I've said that before a few times, yes.
Yeah.
But that was
Thank
a
you
great
so much.
Thank you, Jeff.
Everybody, Steve Elville, unequivocally one of the very best. I know for a fact. I've known him over 20 years. Great presentation, Steve. Really appreciate it. Everybody, thank you for all your questions. Really helpful, great thoughts that you have to share. And Steve, thanks again. We are almost out of time. I'll be sending out a follow-up email in just about an hour or so with some resources. Today's video and the presentation slides again, and the checklists that Steve mentioned, that if you didn't get them the first time for some reason, our presentations move forward as we go into February. We have a busy month, even though it's a shorter month. Next Monday, evening presentation, Estate Planning and Elder Law Essentials on Monday at 7 o'clock with Steve and me. Also on Wednesday, if you're looking for an in-person presentation at Rockville Senior Center, also Estate Planning and Elder Law Essentials with our Senior Associate Attorney, Renee Boyd. That's at 10 o'clock. You can reach out to Rockville Senior Center directly. I'll provide that information in my email to register. Guardianship and the Alternatives at 10 o'clock on February 16th with Steve. And also our new presentation, Maryland's new Decanting Act, Beyond the Vineyard. We won't be talking about wine, but maybe that piqued your interest a little bit. The new Decanting Act that took place in October of last year, we'll be talking all about that. Interesting topic, and look forward to seeing you there February 21st at 10 o'clock with Steve. So appreciate your interest in Elville & Associates. Let us know how we can be a resource to you. And thank you for being part of our webinar series again today. And it looks like we are almost right on time. So have a great day, and we'll see you again soon at the Elville webinar series.